This is the very last recording, and this concerns the medical law in practice. I am Professor Slabbert, so yes, this is the last time you will have to listen to my English. Okay, this is sort of a recap plus a little bit of new information, and it concerns statutory matters. So right at the beginning, I told you that South Africa have a private and a public sector. In the private sector, the doctors are independent contractors, private hospitals are companies, nurses are employees of a private hospital or employees of an agency that provides nurses. In the public sector, it is the state that is the employer. As I've said, we have the National Department of Health and then the 9 provinces with their member of the executive committee in charge of health matters in that specific province. In 2026, we might have the national health insurance. There's still a lot to be done. At this moment, it is just a bill and it is not an act yet. So one must just first of all see whether South Africa can afford it or not. Then we started with the Constitution of the Republic of South Africa and said that these human rights, Chapter 2, are always in the background, and I've highlighted some of the constitutional rights that come into play in the health scenario. I've also said you must remember the National Health Act, but today I add the Health Professions Act. That is the act that prescribes that all health professionals need to be registered with the Health Professions Council of South Africa. Nurses, they register with the Nursing Council, and their rights and duties fall under the Nursing Act, and the same with pharmacists. Then just note that pregnant women in South Africa and lactating women and children below the age of 6, they are entitled to free health services. Okay, whether that happens always or not, I don't know, but that is how it should be. In cases of emergency, life or death situations, I've told you that the private hospital should stabilize a patient who does not have medical aid. And once that person is stabilized, then you move him or her to a public hospital. Once again, this is the perfect scenario how it should happen. It does not always happen like that in reality, and it will be good if someone challenges um, a private hospital in a court case where the person was refused entry because he or she doesn't have a medical aid. So if it is a life or death situation, the private hospital should accept the patient, stabilize the patient who does not have medical aid, and then, when stabilized, move that patient to a public hospital. Okay. I've right at the beginning, I've spoken about the Health Professions Council of South Africa and that they have certain guidelines which are published in booklets, and you can find it on the website of the HPCSA. This will help you in your preparation of a possible case, because it will indicate to you what is expected of any person registered with the HPCSA. So in the booklet, numbers may differ as they add new information or what. So the booklet numbers that I've given to you there, they might have changed now when you go to the website. But okay, there are the ethical guidelines, what is expected of healthcare professionals. You will see there's a patient's rights charter, the self-development incentives that they're not allowed to receive. You can go through that depending on the facts in front of you, where you are going to look for information to build your case. There's some more of these booklets, confidentiality, that links with your right to privacy, or the first one, booklet 9, patient's informed consent, that links directly with the Constitution, the right to self-determination and autonomy. So these are good. Booklet 14, guidelines on patients' records. I ended the previous recording with that RB versus Smith case where the doctor did not keep perfect records, yet he is registered with the HPCSA. There are guidelines on patients' records, yet he didn't keep good records. And remember what I also said, if it's not written down, it did not happen. But okay, those are written, or those have been drafted by experts, and it was done on behalf of the HPCSA. But you can also go to the website of the South African Medical Association. They also have guidelines on their website. Okay. Why do I tell you about the HPCSA, the Health Professions Council of South Africa? Not everyone can afford a court case if something bad happened while being treated by a doctor or in hospital. The big firms, as I've also mentioned earlier, they usually go on contingency. In other words, no win, no fee. They will only take the cases where they are more or less sure that they will win the court case. Then they take that chance. Because if they win, the amount of damages that the court will award will be a huge amount, and then they have the right to take 25% of that amount for them presenting the case. So it will cost the plaintiff nothing, no win, no fee. So it is the legal firm that takes the risk. But the legal firms won't take all cases because they sometimes feel it is not worth their while. They will not make enough money. The court cases are usually a few years, so they will need capital to go through those years until judgment and damages are awarded. So what then do you do if you've been treated badly by a doctor or in a hospital or privately or whatever? So you are angry. Something was bad. The person did not perform his duty with the necessary care and skill. You don't have the money to go and see a lawyer, yet you don't want to keep quiet. You don't want another patient to go through the same bad ordeal that you went through. Then you can report that doctor, any person who's registered with the HPCSA, doctors, physiotherapists, speech therapists, dentists, then you can go and report them to the HPCSA. You can go to the website of the HPCSA and the procedure is explained there. In other words, you as the patient who are angry or who suffered damages, you must now write your version and submit it to the HPCSA. When it goes to the HPCSA, it is scrutinized. If it seems minor, that it can easily be resolved by just speaking to the two parties, then the ombudsman will handle it. If it is decided that there is more to the case, there's a little bit of problem, it seems as if the person acted unprofessionally, then it will be referred to a disciplinary inquiry. During that inquiry, then it is the patient who now indicated, I have a problem, this is my side of the story. The committee will then notify the doctor or the person involved of who's being accused, and they will have the opportunity to state their case. Then the disciplinary inquiry will take a decision, and they will see what was the patient's case, what was the doctor's case. If they feel that it warrants a disciplinary hearing, it will go to that stage of unprofessional conduct. Then there will be a whole disciplinary hearing where both parties will be allowed to state their cases, to call witnesses, to be cross-examined, etc. And then the disciplinary committee will come to a conclusion. And if you are not satisfied with their conclusion, you can appeal. You can appeal. There is an ad hoc appeal committee at the HPCSA, or you can appeal to the High Court, or you can ask the High Court to review the disciplinary process. Once it went to the High Court and you are still not satisfied, then it can even end up in the Supreme Court of Appeal. So I've given you a few very short bullets, but if you go to the website, you will get the detail there. So this is one way, instead of going to court, to at least report a doctor that gave you bad treatment to his professional body so that he or she can be disciplined and not do or treat another patient as badly as they have treated you. So this is an option if you do not want to go to court. There I have listed a few cases, 3 cases. The one is an old case, and then there's a newer case, and there's a 2022 case and a 2021 case. It is just so that you see how it happens. The first one is the worst, and usually we like asking the first one, the brain case, for an activity, because that forces all of you to go and read that case. Right from the beginning, I want to state that it happened in the old South Africa, where it was still the Mental and Dental Council. In the new South Africa, the name changed to the Health Professions Council of South Africa. But that case went all the way from a disciplinary inquiry to a disciplinary hearing to the High Court to the Supreme Court of Appeal. So I want you, well, it took many years, but I want you to read everything. Certain parts of the court case is quoted in Afrikaans because the claimant, the woman who complained, was Afrikaans speaking. But if you don't understand those pieces, it doesn't matter because the summaries are given in English. You will follow the whole process, even though you can't read her testimony pieces of that in Afrikaans. It's a terrible case. It is really, really a terrible case. And I really want all of you to read it. And at the end, to decide whether you think the process that was followed was fair, or were they too lenient, or were they too harsh. Briefly, and this is very briefly, as I say, I want you to go and read this case, and you will enjoy it. It's gross, but you will see a lot of things. The guy was still a medical student, and his girlfriend fell pregnant. And he tried everything. He even borrowed equipment from the hospital, and he tried to give an abortion. It never succeeded. Eventually, the fetus was cut up into pieces in her body. And then he was so arrogant that he forced her to drive home by herself. And when she came home, there were still pieces falling out of her body that she had to pick up and flush in the toilet of this fetus. It is just terrible. Besides that, when he tried to perform the abortions on her, he gave her alcohol so that she became relaxed, and then even had sex with her when she was in that state. So eventually, yes, the abortion was a success, but the relationship did not survive, and the girl became very depressed. And then she told her mother what happened. And then the brain was reported at the then Dental and Medical Council, and there was an inquiry, and he was found guilty, but then he appealed, etc., etc. So I want you to read it. As I say, it is bad, and decide for yourself whether you think the judgment was fair or not. Ludwig, you can just read. It is a new case. It is in 2022. That is where um, a person registered with the HPCSA also provided other services, and then there were complaints and an investigation. The third case there, the grief case, is a doctor who influenced his patients to buy into an investment company of his, and yeah, and it didn't go well, and he was accused of unprofessional conduct. But those cases will help you if you are a lawyer who represents people at the HPCSA. That's good to go through those cases to see the processes followed by the HPCSA. Then in your study material, you are also referred to other laws, and I'm not going to go into detail. I only want to warn you that when you are working with the mentally ill, same as with children, be careful. The mentally ill, any scenario where your client alleges medical negligence in a mental health care situation, you have to read the Mental Health Care Act, and you have to work through a review board. And there I've quoted a case for you. But yes, mentally ill and children, those are exceptions, and you must be careful, and you must consult the specific laws, the Children's Act for children and the Mental Health Care Act for the mentally ill. Okay, then there are other laws also applicable, and I've said that quite a few times. I've referred to the Consumer Protection Act. Can you remember I spoke about the AFROX case, the indemnity clauses in hospital admittance forms? And I've told you that the AFROX case, it's a Supreme Court of Appeal case, and it is still the ruling case on indemnity clauses until someone will challenge it and will go to court under the Consumer Protection Act, because that act was not effective yet when the AFROX case was adjudicated. So under the Consumer Protection Act, a patient is a consumer, and service is the treatment of the patient. And then, of course, the doctor or the hospital is the service provider. But you need to take note of the 8 fundamental consumer rights, and you will see it's more or less the same as the Constitution. Everyone is equal before the law. Privacy, if there's no informed consent, it can be seen as an invasion of privacy. Autonomy, self-determination, you can choose who treats you, and a patient has the right to refuse treatment. A patient has the right to refuse treatment. In other words, you cannot force a patient to take certain treatment. Although we do not have a right to die, because euthanasia and physician-assisted suicide is illegal in our country, a patient has the right to refuse any help or any medicine. That is your autonomy. The inform of risks, yes, you must be informed. That is also part of informed consent. So if they are going to use donor bone in your jaw, for example, they must explain to you the risks by using that. Or if you get a pacemaker or any other prosthesis, breast enlargement, etc., the doctor must inform you of the risks of putting those equipment into your body. Okay, then also under the Consumer Protection Act, the hospital is obliged to provide quality medical services. Well, one can argue that doesn't necessarily happen in the state sector, but sometimes also not in the private sector. Section 51, the exemption of liability for loss or damage due to gross negligence is not permitted. Then the chain. What does the chain mean? For example, let's say you've got a heart problem. So the cardiologist suggests that you should get a pacemaker. You go for the operation. The pacemaker is put into your body. A few months later, there is a problem and you paid a lot of money and it doesn't work. Then according to the Consumer Protection Act, you can now sue everyone in the chain: the producer of the pacemaker, the importer, the distributor, the retailer, and the doctor. You can sue all of them for the damages that you suffered because of the faulty pacemaker. Of course, it will be difficult to find the producer, importer, distributor, etc. But you have the right to sue all of them. You will most probably start with the specialist, the cardiologist. But then he can say, but you need not only sue me, you must sue all of them in the chain. That is if you go and you sue under the Consumer Protection Act. This now is not the same if you institute action on the basis of a delict or a contract. If you purely go on the Consumer Protection Act, then you have that right to sue everyone in the chain. Okay, you don't necessarily just go directly to court. You go to the National Consumer Tribunal or the National Consumer Commission, who will do investigations first. And then when the issues cannot be resolved, then it might end up in a court of law. Then you should also take notice of the Protection of Personal Information Act, which became effective in 2020. It and the people had 1 year to comply, so that already happened in 2021. But yes, health information or personal information, but also specific information, and it is widely protected under that act. There hasn't been any cases yet, but it might happen in future. So just take note that that act also is part of medical law in the health context. Okay. At the beginning, when I told you that medical law is extremely interesting field, and I said, because it is not always black and white. Sometimes there's also an ethical dimension, and that is what makes it so extremely interesting. So let's just talk and look at a few examples. Let's say, for example, there's a 74-year-old man. He got a heart attack. So the ambulance is called. He's in the ambulance. His wife is with him, as well as his son. He's still conscious. In other words, he is under tremendous pain, but he is not unconscious. So he tells the ambulance people, the emergency workers, please leave me alone. I want to die. The wife then say, my husband has a living will. And I don't have it with me, but it is somewhere in his home office. The other family member, let's say it's the son. The son tells the ambulance people, you will do whatever you can. I do not want my father to die. What now? 74. He is, he is not perfect. He's under pain, but he's still not unconscious. And he says, leave me alone. I want to die. That should be honored because of his autonomy, because of his constitutional right to self-determination. The woman can only agree because she knows there's a copy of a living will. Remember, a living will has no legal validity. You cannot sue on the basis of a living will. It is only a directive. So in this instance, the son should be overruled. But it is not that easy. This is what we can now say looking at it from the outside. But when you are in the situation, it might not be that easy. But then you must think and you must remember and analyze it like this and remember a person's autonomy if that person knows what he or she is doing. Let's take the next one. Mrs. V, she's 45. She is under the care of a psychiatrist because she tends to be depressed a lot. Then she goes to the doctor who must now see whether she's got cancer or not. So he must do a biopsy, whatever. He must see. But the husband say, if you get the results from the laboratory, you will then either confirm that she has cancer or say that she does not have cancer. The husband say, I want to know first, because he realizes that his wife might not be able to appreciate it. Yet, the relationship is between doctor and patient, confidentiality. So, what now? Must the doctor tell the husband first or not? So, it's the woman's autonomy versus non-maleficence. Non-maleficence means do no harm. Plus, there's something that also comes into play, therapeutic privilege. The doctor can decide what to tell a patient or not. If it's not in the best interest of the patient, he can keep some information for himself. But looking at that scenario, does the husband have a right to ask that? It's difficult. You will find no law that will help you. You will only argue confidentiality, privacy. But now she is under the care of a psychiatrist. She is depressed. If she hears she's got cancer, she might commit suicide. So the doctor must now weigh up all of that before he or she makes the decision whom to tell first. See how interesting medical law is. Let's take another example. A baby is born normal, but at 35 weeks. So the baby is premature. Once the baby is out of the uterus, he or she has a difficulty in breathing. And the pediatrician also realized there's muscle problems. This baby cannot swallow. Therefore, he suggests to the parents, this newborn premature baby must go for surgical procedures. Otherwise, he will never be able to swallow or to breathe. And he cannot guarantee that the operation will help, but they must try. Maybe he will never be able to swallow, and then he must be fed with tubes. So he explains everything to the parents, the pros and the cons and the risks and whatever. And then the parents say, no, they won't give permission for the surgical procedure. They rather want the baby to die. They also have no funds anymore to pay for the procedure, the ICU bill or whatever. What must the doctor decide? What should happen in a scenario like that? Say, for instance, you are the legal advisor for the hospital and they come to you with the facts. It is a difficult situation. Each of one of you must think, what do you think will be the solution? Is there a duty to save life, irrespective of the quality of life? Let's make it a little bit more complicated. The parents refuse that the operation should be done. And they say, the moment this baby is unconscious or doesn't function anymore, all of the organs must be taken and given to other premature babies for organ transplants. So at least their baby's life has meaning by saving 7 other premature babies. Could that be done? You see, it is not clear. You don't always have an act or a specific guideline, so you must now look at autonomy, self-determination, the Children's Act, the right to life, the right to dignity, and weigh all of those things. And that's why I say medical law is so interesting. Let's take another scenario. You're a legal firm, you take a case. It's cerebral palsy. You will probably get damages paid out in the vicinity of 30 million. You, in the 6 years that this court case is dragging, you've spent thousands of rands in the litigation process. But the final award has not been given yet, and the child dies. In other words, you won't be able to claim future medical costs, loss of earnings, pain and suffering, loss of amenities of life. So your claim for damages now becomes much smaller. So your part of contingency becomes much smaller, yet you've already spent a lot of money. What do? Do you tell the court that the child died? Is that your ethical duty? Do you keep quiet until judgment is given? What should happen? I don't know. You you must think. Let's take a completely different scenario. They, there's people on a transplant list that needs an organ transplant. Now, in our country, they usually use blood relatives. But the husband and the wife is not suitable. But there's another husband and wife which is not suitable. And there's another husband and wife not suitable. So there are 6 people involved. 3 needs an organ. 3 are willing to donate, but they are just not compatible with their specific person. But if they cross donate, then all 3 can get a transplant, and all 3 donors will hand over one of their kidneys. So it is accepted, and the hospital is ready, and they will do it. But the evening before the operation is done, on those 6 people, 3 donating, 3 receiving, the doctor overheard a conversation and realizes that one of the recipients are paying for the kidney, which is prohibited according to the National Health Act. If he or she speaks, then it's going to affect all 6 people. Do you say that? Do you report that to hospital management, or do you keep quiet? Because otherwise 6 people's lives will be changed. Of course, if you go pedantically according to the National Health Act, it is illegal to pay. So you will say, stop, we must stop all of that. But is that in the best interest of all the others? You can think for yourself. Okay. This is the end, and I'm going to close now. The exercises have been included in one of your study units. We do not provide the perfect answer for those exercises because we just want you to see how a possible medical negligence case can look like. Each of one of you will approach it differently, etc. So we don't give a model answer, we just give you the idea of what it looks like. Then I want to end with a very interesting case. Just that one. The other one you can go and read for yourself if you want to. The last one is a criminal case, and that is just for interest. But the ABC case, it's a case from Singapore, and it's extremely interesting. It concerns reproductive rights. So what happened in that case is it is a Chinese woman, but she lived in Singapore. So she's a Singaporean, um, and she married a Caucasian German guy. They could not conceive naturally. So they went to that Thomson Medical Company who does in vitro fertilization. So they took the sperm of the Dutch husband. They took the eggs of this Chinese Singaporean woman in vitro in the laboratory. The sperm and the eggs came together, and then it was replaced in her uterus, and a baby was born. Of course, they are the natural parents. It was her egg, it was his sperm. They just couldn't conceive naturally. So beautiful baby was born. They were very happy. But you don't when they take an egg of a woman or the sperm of the men, they usually keep more of it in case something goes wrong. So they knew there were still eggs from her and sperm from him at that specific laboratory. So 5 years later, they approach the laboratory again and say, okay, we now want another child. So you still have some of my eggs and you still have my husband's sperm. So once again, in vitro in the laboratory, and let there be an embryo, and we want another child. And everything went on. And when the baby was born, when she came out, she was black Indian, very dark Indian. So she didn't look like either the mother or the father or the brother. Now, what now? And that is why I say medical law is so interesting. Now you go to court. They wanted a baby. They definitely wanted a baby. They could afford a baby, but they didn't want that baby. They want a baby from themselves. Now, what must the court do? Okay, of course, there was an investigation. The laboratory said they were negligent because there was a mix-up with the sperm. So she didn't get her husband, the a Caucasian man's sperm. She got an Indian donor sperm. So, of course, the laboratory was negligent. They were fined. The people were disciplined, etc. But what now? There's a perfectly healthy little girl. They wanted a baby. They didn't want that baby. It is a sad, how can the, the court or how can those circumstances be judged? There's a perfect baby, yet not the right baby. Then judgment was given for the loss of genetic affinity. So they were awarded an amount just to make up for this this bad outcome. Unfortunately, all ended well. They loved the child and they accepted the child. But there's a lot of other issues because now the child is not genetically linked to the father. If the mother and the father now divorce, will he have a duty to support that child because that child isn't his? There's no genetic link. So I want you to read that case because it is based on contract. It is based on delict. It is a thick case. It is very well argued. And we follow the same common law. So it can also be relevant in South Africa. But just to see, sometimes courts are faced with very emotional issues and it is not always easy for the court then to give a judgment because something bad happened. I have spoken a lot, and I think you are all now tired of my voice, but I want to thank all of you for being part of this module, and I really hope you've learned something. And if I went too fast, remember, you can go and re-look and re-listen to what I say until you feel comfortable that you understand and enjoy what you are doing. So for the last time, thank you very much and goodbye.